You're rocking with the best.
Let's go. Watch out. Hey.
You're rocking with the best.
This is part of an ongoing series where I am hosting, bringing in professionals who actually makes a career out of the things they do to come speak at my events. So you're not only getting the new culture, you're getting the professionals too. Because we obviously are on the same page. I spoke to him for some of the topics is going to be what really happens in a refinance. One of the top is going to be what really happens in a foreclosure. The mortgage-backed security side, the investor payment side, how the structuring goes, how the payments goes.
I'm telling you, Lamont, I haven't got to talk to you since yesterday.
Yeah.
But I talked to that Deloitte head supervisor that's with Deloitte, and man, she put me on some magic. But everything that you have been saying has been, razor blade.
You're rocking with the best.
Wow. Oh yeah, we gotta talk. So
Supreme Elite Team. New culture empire. Turn the lights up. Runners go higher, yeah. Thomas lit, numbers on fire. Every screenshot, wired to the choir. Real deals, he ain't gotta say a thing. Receipts in the cloud, make the phone sing. Meanwhile, she frontin', posing by a gate, talking about a mansion. Paper came late, walked in stunning. Ink still wet, whole bank laugh, card say reject. Hey! Supreme Elite Team, we don't move like that. New culture empire, better break by jail. They cap online, we cash offline. You can't fake crime when it's game time.
So if the borrower is always defined as the grantor, then what the hell does grantor mean? Grantor, it just means that you have the ability to grant something. We're going to keep it stupid simple. We're not going to overcomplicate this. If I'm a grantor, that means I have the ability to grant something. What am I granting? You start having to ask these questions, guys. You got to ask questions. All right, the continuation. If you are the grantor, it means that you are the one that funded the contract. This is your standing. Y'all gotta follow me because I want to teach you. I don't want to just help you extinguish your mortgages, guys. I really like people who want to learn the process, so don't mind me, all right? This is how I teach. But if you are a grantor, that means you're granting something. That means, guess what? You are the one that funded this contract. And for those of you that get a little ahead, yes, this contract is a trust, and you should know where I'm going with this. So you're going to scroll all the way down in your deed of trust, and you're going to see this beautiful, beautiful section called transfer of rights in the property. When you get to this section, y'all, all right, it's going to read, the security instrument secures to lender the repayment of the loan in all renewals and modifications of the note. I'm going to say that again. The security instrument, meaning this deed of trust, this security deed, this deed of trust, whatever the hell they want to call it, right, secures to the lender the repayment of the loan. Stop right there. So you telling me the actual instrument itself pays for itself? That's That's exactly what this just told you. Y'all overcomplicated because you weren't taught how these things work. You weren't taught how to actually perform, okay? We don't pay for things around here. We perform our duties. Stay with me. You got to start learning what these words really mean, okay? So that means the security instrument basically pays for itself, y'all. That's exactly what this means. All renewals and modifications of no loan, it don't matter what they do, flip flop it, whatever they want to do with it, it pays for itself. Fact check me. Y'all know how I roll. Fact check me. Y'all know how I roll.
Fact check me. Y'all know how I roll.
The defendant creates money out of thin air and burdens the plaintiff through a debt slave. What did I tell you? What did I tell you? The vapor money theory. Yeah.
So you telling me the actual instrument itself pays for itself? That's exactly what this just told you.
The vapor money theory. Oh, you ain't loaned me nothing. You created out of thin air. You ain't really gave me nothing. I don't got to pay it back now. Well, when did you find this out? When I was $5,724 in debt?
You're rocking with the best.
Every move in the booth. Talk checks. He could pull that thread, pull that PDF, make the cap turn.
Welcome to today's live stream, hosted by none other than the New Culture Empire. Today, we break down mortgage cases as we near closer to the Summer of Professionals series. Don't forget to reserve your slot for this special presentation by a real professional, Mr. C.L. Hicks, Senior Supervisor IT Analyst for Investor Relations. Fannie Mae. We also want to thank you all for helping this video reach 10,000 views. Let's keep pushing, growing, and discovering. Don't forget to hit the like, subscribe, and join the Patreon, and send an email for all inquiries.
You're rocking with the best.
Sir. Yes, sir.
You're rocking with the best.
Yes, sir. Let's get it.
You're rocking with the best.
Back in the building, back with another one. Back on top of the game. This is another live stream by the New Culture Empire. QR code is there. You can scan it off your phone, QR code. You can reserve your seat. We will be having the professional CL Rex, Senior Supervisor Analyst IT Investor Relations. He is going to give a 100% professional presentation dealing with mortgages, mortgage-backed securities, refinance there, the note there. And I'm actually excited myself. I'm actually going to be, I reserved my seat just like everybody else who has already. I reserved mine. I will be in the audience along with you all. One thing for those who've already reserved, if you have your questions, that if you have potential questions that you want to be asked, please have your questions submitted to me in the email by July 11th. The reason being, because I want to get your questions asked and have them on cue for him. So when we get ready, get to the Q&A section, when we get down to the engagement part, we can get your questions. We get your questions asked. I'll read the questions off. First name, last name initial, question, so you know when your question is being asked, so you can get your answer. This will be held on Zoom, okay? This will be held on Zoom. No, you cannot record this. The recordings are going to be made available after the class. Once again, this is still proprietary property, intellectual property of the Accrual County Collection Agency Corporation. The New Culture Empire is owned by that. The Supreme Elite Team is owned by that. Okay, so just keep that in mind. Keep everything on the up and up. So today, as we get closer to the mortgage, the presentation, first of all, shout out to everyone. The in-court client case from a few weeks ago has now surpassed 10,000 views on YouTube. Yes, sir. So, let's. I don't know how many times I have to say this, but I'm going to say it again as many times as needed. I want to run something back. I want to run something back for a second because this was a very interesting, and I will be actually breaking. I guess we can start there. I will be breaking videos 1, 2, and 3 down. It's going to be a 3-part series. It's going to be a pre-recorded video, no longer than 10, 15 minutes each video. But let's actually break this down. Let me try to understand first before I come to my conclusion.
The borrower is always defined as the grantor. Then what the hell does grantor mean?
Question: what does the grantor mean? What does the grantor mean? Hey, if YouTube's not sending a notification, kind of got to hit the bell, re-hit the bell, or, resubscribe and turn notifications all on. I don't know what else to tell you. They should be lifting the shadow ban soon. They've been pushing that video on the algorithm, so maybe they should be lifting the ban soon. But whatever it is, let's get to it.
Grantor, it just means that you have the ability to grant something.
Okay, so her interpretation of grantor means that you have the ability to grant something. All right. So let's actually go. And I have a mini website set up so you can reserve your seats as well. I got my mini website set up so you can actually reserve your seat. I will be posting that link so you can actually reserve your seat here. Just go down, simple, nothing major. You can reserve your seat here. Right here. You can take care of it all right here. Confirmation email. Your understand, your phone number. Always going to ask for your first name, last name, phone number, email, address. Bam, straight to the point. But she says that grantor means you have the right to grant something. Okay. So, yeah, I did this backwards. Shouldn't matter. So, this is the part where remember when, prime example, remember when I always say the professionals, that's why it's good to have a professional view of it, because we may be looking at things different from the way they view things, right? Remember, we may be looking at the form different from how they view the form. Hold on. Remember, if our view of what the form is used for, or our granting, if that's different than what they say it is, remember who controls in this situation? Hold on, I'm trying to get the 1003 form. So let's do this. Fannie Mae 1003 form PDF. All right, so let's get this form. I want to go straight from Fannie Mae. All right, here we go. Application, PDF. All right, we got it. So This form, I'm pretty sure a lot of you understand this form. TikTok, we are live at the New Culture Empire on YouTube as well. So if I'm sharing my screen, you can't see it. That's because I am on as well. I will try to link both together. So when I go live, share my screen, y'all TikTok to be able to see it well. But anyways, y'all can follow along. Y'all smart enough. So this form here, if you go down, of course, they're talking about your information, job information, your business, other income. But let's go down here because this is why I'm surprised when a lot of these gurus are saying the things that they're saying. I am surprised. So let's go down to zoom in. Let's go down to number 2 on page. Number 2 on page. I'm gonna say it's gonna be page 7 or page 8, but it's down here at the bottom, page 7. So go to section 2, page 7, right? The loan I had applied for in this application will be secured by a mortgage or deed of trust, which provides the lender a security interest in the property described in this application. That is what the grant means. The grant. It should. Okay, so stream. I don't know what's. Okay. Why is it still stuck on that page? Let's reshare it again. Y'all, I swear to God, I swear, ever since I made the change to Verizon, it's been horrible. Horrible. Even when I'm 2 feet, like an inch from the router, it's horrible. 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 Verizon gets a minus whatever the lowest rating. Horrible. So the loan I've applied for in this application will be secured by a mortgage or deed of trust in which provides the lender a security interest in the property described in this application. So the way the professionals see it, the way Fannie Mae sees it, the way Ginnie Mae sees it, the way your lender sees it, is that the grant in which you are granting the lender or their successors or their assigns or the note holder or the owner, whoever, you're only granting them a security interest in the property. Meaning, although you are the owner of the home, they have a security interest. Remember I told you a person with a security interest is in a far superior position than the owner. Remember, you having a title to a property means nothing. You being the owner to the property means nothing if there's a lien on it, a security interest, meaning you are granting the lender the right to take back possession, MREM, take possession of the property, have a claim against the property, take back possession, foreclose on the property, to sell the property in order to satisfy the underlying debt which evidence against the note. That's the only thing you're granting to them in the mortgage. You're not granting them any money. You're not granting them any type of extraterrestrial security interest of any nothing. You are granting them as a part of the condition of you getting a mortgage. You are granting them a security interest in the property, meaning that property that you own is subject to the claims and it's subordinate to the claims of the lender or their successor or assigns. That doesn't magically mean that you provided the money. That doesn't magically mean that you have a situation where you're entitled to a legal set-off or a legal netting of the account. That's not that situation in the standard mortgage. So when the young lady makes the statement,
it's stupid simple. We're not going to overcomplicate it. We're going to keep.
When she makes this statement,
the borrower is always defined as the grantor. Then what the hell does grantor mean? Grantor, it just means that you have the ability to grant something. We're going to keep it stupid simple. We're not going to overcomplicate this. If I'm a grantor, that means I have the ability to grant something. What am I granting?
Right there. This is the part where social media teachers run smack into the wall of the professionals in the system on how it operates. This is where you see the contrast. The question she poses, what am I granting? Now, for the purpose of her theatrical performance here, she can't say we're granting them a security interest in the property, because that totally refutes everything that she's about to say next. But if we go to what Fannie Mae is saying, Fannie Mae is saying that's exactly what you're doing. The loan you have applied for will be secured by a mortgage deed and trust, which provides the lender a security interest in the property described in this application. So now we have to fork in the road. So you have a social media teacher saying one thing, but you have the professionals saying something different. Ask yourself a question, and this is a Fannie Mae application. Ask yourself, if you have to choose between this young lady and Fannie Mae, if you had to choose, if she's saying it goes this way, Fannie Mae said, no, this is not what it means. Who are you actually going to, in real life, not social media, online, who you like, in real life, when you had to make a decision, who are you going to side with? You're going to side with Fannie Mae. We know that.
Start having to ask these questions, guys. You got to ask questions. All right, the continuation. If you are the grantor, it means that you are the one that funded the contract.
Right there. She says, if you are the grantor, and this is where you have the filling in the blanks on my underlining belief system, my underlining how I believe or I think or how I interpret how the system works. And this is when that gets, it never fails. This is when that gets inserted into the situation, when now this is nothing more than an opinion or belief. Factually, she is inaccurate. And this is how misinformation spreads. When you have to fill in the blanks, when you don't understand, you have to fill in the blanks to what you believe is true. So now the average person that's listening to this, they're automatically thinking that you, yourself, you funded your own loan. Let's hear it. Look.
All right, the continuation. If you are the grantor, it means that you are the one that funded the contract.
Funded the contract. But when we go here, Fannie Mae is saying the loan you have applied for in this application will be secured by a mortgage or deed of trust, which provides the lender a security interest in the property described in this application. So, according to the government, you are granting them the right to take possession of the property in case you default. And you are granting them that right. So it's called a confessed judgment. You're basically saying, if I default on this mortgage, I am granting you the right to take possession of this home. And they call that a security interest. A security interest is a far superior position. I don't care if you own a 50,000 square foot home. If I have a security interest in your home, I can snatch your home, sell your home to satisfy the underlying debt. This is where it gets dangerous.
Y'all gotta follow me.
You can dance all you want, young lady. You could do all the dancing heel to toe all you want. You are still factually incorrect.
Because I want to teach you. I don't want to just help you extinguish your mortgages, guys. I really like people who want to learn the process, so don't mind me, all right? This is how I teach. But if you are a grantor, that means you're granting something. That means, guess what? You are the one that funded this contract. And for those of you that get a little ahead, yes, this contract is a trust, and you should know where I'm going with this. So you're going to scroll all the way down in your deed of trust, and you're going to see this beautiful, beautiful section called transfer of rights in the property. When you get to this section, y'all, all right, it's going to read, the security instrument secures to lender the repayment of the loan in all renewals and modifications of the note.
Ma'am, you don't even realize by you just doing that there, you contradicted your own self. You just invalidated your own self. Okay, once again, I tell you, I don't know how many times. I don't know how many times. I don't know how many times we have to do this. And this is why the Summer of Professional series is so important. And I know, yeah, many people don't really like to deal with professionals. I know they don't like to deal with professionals because I don't know why it keeps doing this. I really don't know. I really don't know why it keeps doing this. I know they don't like to deal with professionals because they know a lot of times the professionals is always going to say something different than what they believe is true. And, you know, you got to save face in this space. The gurus, they have to save space, save face. So they're not going to come out and tell you that they're wrong. They're not going to tell you that they've been wrong. Let's go here. All right. So let me share my screen. Let me share my entire screen so y'all can I just don't understand why she even thinks that she legally, like, you legally okay, right here. This is a standard Fannie Mae, and this is out of state of Florida, right? And she said, go down to the application of payments. And you notice how, before you get in here, right? You know, before we get there, right? You notice how, if you look at all these definitions, if you look at all the applicable definitions, default, okay? You know what default means? Failure to pay any periodic payment or any other amount secured by the security instrument on the date it is due. So when you raise a breach of contract, but you're in default yourself, you kind of breach the contract yourself. But you notice what it doesn't say here? It doesn't say what? FDCPA. You see? RESPA, it doesn't say FDCPA. So, watch this. Borrower represents, warrants, covenants, and agrees that borrower lawfully owns and possesses the property conveyed in the security instrument in fee simple, or lawfully has the right to use and occupy the property under a leasehold estate. Borrower has the right to mortgage, grant, and convey the property or borrower's leasehold interest in the property. And 3, the property is unencumbered, and not subject to any other ownership interest in the property except for encumbrances and ownership interests of record. You get what I'm saying? So it means that what they're basically saying is, when we get into this agreement, nobody else has a superior interest in this deed of trust, but in this property, but us. Now, when you go here, she said that you funded the contract, you funded the mortgage. So Look at the language. Borrower, uniform covenants. Borrower and lender covenants and agrees as follows. Payment of principal, interest, escrow items, prepayment charges, and late charges. Borrower will pay each periodic payment when due. Once again, if you loan them something or if you funded the contract, besides the answers of it's a trick, they're tricking you, they deceived you, they pulled a fast one over you, they got you to pay twice. Besides that answer, because that is an answer that you can easily give to shut down any thought-provoking conversations or any talk or conversations or subjects that may cause you to reevaluate how you see it. So let's put all the defensive armors down, strip yourself of your belief, and ask yourself from a logical standpoint, if I am actually the creditor, if I really actually lent something to them, why does the language say the borrower will pay each periodic payment when due? Besides the cliche answers, ask yourself, is the language indicative of someone who lent the lender something, or is the language indicative of someone who was going to borrow something from the lender? Just the language itself. Because we could put the theories aside. Let's just go what it says, black and white. Let's just follow the language, right? Now, the borrower will also pay any prepayment charges and late charges due under the note, and any other amounts due under the security instruments. Once again, how does that equate to you funded something? You loaned them something. Why isn't that in writing? They got everything else in writing. Why is it that when it gets down to the so-called borrowers actually funding the whole loan, why is it so secretive? Why is it so you just got to understand in order to know, when everything else about the transaction, albeit it may, be some other little things in there, but for the most part, it's in writing. Now, if payments due under the note and the security instrument must be made in U.S. currency. Now, before we get to the semantics on U.S. currency, ask yourself, if you had a wire transfer from your checking account of $2,750 to pay your mortgage, right? You had immediate access to click the send button. Or you have an international promissory note in your hand right now. What method of payment do you think will bring security and knowing that the payment will be accepted? Which payment method? Just at a glance of looking at it. Okay. Second question. Which payment method do you think will likely be used if when you click that send button on the wire transfer and you send that $2,750, that will be all the money you have again until next month. Pretty much you're broke for the rest of the month. Now, you can still click that $2,750, or you can tender the international promissory note. Now, which option do you think people in these spaces would use? You see how it goes? Okay, so U.S. currency. Now, if any check or other instrument received by lender as payment due under the note under the security instrument is returned to the lender unpaid, lender may require that any or all subsequent payments due under the note and the security instrument be made in one or more of the following forms selected by the lender. Cash. We all know what that means. Money order. We all know the process of what a money order is. You have to give them cash. Or certified check. bank check or treasurer's check or cashier's check, provided any such check is drawn upon an institution whose deposits are insured by a U.S. federal agency, instrumentality, or entity. You know what that means? It doesn't mean the U.S. Treasury, because the U.S. Treasury is not insured by the FDIC. So they're basically saying money that's in your account, and the cashier's check, treasurer's check, bank check, money already has to be deposited into your account in which the check is drawn on. Want to know why? Because when I had to make a payment to the contractor, I had to pay $5,400. You know what I did? I had to take $5,400 cash, deposit that $5,400 into the account, and I went to the teller at Navy Federal, and they wrote a check right there from the account. You know what I'm saying? All right. So we don't have to get into the we have to get into all that. So now she says another thing that caught my attention. Now let's get down to the payments. All right. Let's get down to these payments. All right. So these are getting to the insurance, prior rights under the security instruments. So let's get right here. This is actually funny. Actually very good. This part right here. Protection of lenders' interest in the property and rights under the security instrument. If 1, borrower fails to perform the covenants and agreements contained in the security instruments, there is a legal proceeding or government order that might significantly affect the lender's interest in the property and the rights under the security instrument, such as a proceeding in bankruptcy, probate, for condemnation or forfeiture, for enforcing of a lien that has priority or maintain priority over the security instrument, or to enforce laws or regulations. Or 3, lender reasonably believes that the borrower has abandoned the property. The lender may do and pay for whatever is reasonable, appropriate to protect lender's interest in the property, including assessing the value of the property, repairing, etc. Now, the lender can pay sums secured by the lien, has priority to maintain, appearing in court, paying attorney fees, etc., etc., etc. So basically what that's saying is the lender, everything about a deed of trust is securing the lender's right into the property and securing the payment. Why does the lender have to have this in writing with you? Because when the lender's rights are secured under the security instrument, then Fannie Mae's rights are secured as to their obligation to the investors. You get what I'm saying? It's a double-edged transaction. You got one transaction going on multiple different ways going on at the same time. They're all interconnected. It's always about 4 or 5 transactions going on at the same time, all started from that one transaction. 4 more transactions are taking place. And they all are interconnected, and one hiccup in one affects the other 3. Now, any amounts dispersed by lender under this section 9 will become additional debt of borrower secured by this instrument. These amounts may bear interest at the note rate and from the date of disbursements, and will be payable with such interest upon notice from lender to borrower requesting payment. If the property is leased, used by or occupied by a third-party tenant, borrower is unconditionally assigning and transferring to lender any rents, regardless of to whom the rents are payable. Borrower authorized lender to collect the rents and agrees that each tenant will pay the rents to the lender. However, the borrower will receive the rents until the lender has given borrower notice of default pursuant to section 26. And 2, lender has given notice to the tenant that the rents are to be paid to the lender. This section 10 constitutes an absolute assignment and not an assignment for additional security only. Once again, What about this? What about this says that you lent something to them? We got to move away from the theories and get straight to reality. Notice a default. Does they say anything about a set off if you in default? It says, nope. Everything is about not paying. You see? There's nothing here. Now, let's go. Not going to really discuss that because that's going to be discussed that was discussed in mortgage reality class part 3. So I'm not going to discuss that. Not really going to discuss that now. So when we continue to scroll down and we get to the notice of borrows, we already get to the electronic note, governing laws, and all this. Beneficial interest in borrower's right to reinstate the loan after acceleration, loan servicer, grievances. There's nothing here. And I'm trying to figure out, why is it that it's always the gurus? Why it's always the gurus that seem to know more than the actual people who created the contract, who put it together?
I'm going to say that again. The security instrument, meaning this deed of trust, this security deed, this deed of trust, whatever the hell they want to call it, right, secures to the lender the repayment of the loan. Stop right there.
Like we just went down. So the security instrument, that is the contract that you sign in which you are agreeing to the terms of payment, when the payments are going to be made, the application of the payments, who gets the insurance proceeds, what happens in the insurance payout, borrower assigning your rents over. Everything is you assigning the payments, the rents, the insurance proceeds, all that to secure their interest. There's nothing about a security instrument that has anything to do with you or the security instrument itself. Because the underlying collateral is the home. The note is evidence of the debt. The evidence of the debt is going to be fulfilled by your monthly payments based on whether the rental income that you plan on getting from the property, and 2, your job. This is why they have your job information down. How much money do you make? So they can do their loan to value ratio. But there's nothing about the security instrument that says this security instrument itself functions as payment. There's nothing there. Nothing.
So you telling me the actual instrument itself pays for itself? That's it.
See? You mean to tell me that the actual instrument for itself pays for itself? Do you know how less of a headache it would be if that was true? Do you know how less of a headache it will be for them? But ask yourself this question. How does that security instrument function as the payment? What's the underlying cash flow that's going to secure that security instrument if the instrument itself is the payment? The instrument itself is not a negotiable instrument. The instrument itself is a security instrument for the purpose of securing the lender's interest in the property, securing the repayment. So ask yourself once again, how can you effectively present to the lender that the security interest itself is payment? That will be recognized in a legal setting or by their compliance department. So when they get to these discharge mortgage things, or it's going to be discharge, ask yourself one question. How do I accurately explain the accounting for the discharge? from the accounting authoritative guidance that they recognize in their corporate finance system every day. They're not going to accept any outside methods that are not aligned with the authoritative guidance tells them how to account for these things. So if it's not written in the rules, not written in the accounting mandates, or you don't understand accounting like they get you to believe it's so easy to understand, you're going to find yourself in the pickle. But let me just say this. There is no way on God's green earth that the security instrument itself serves as the payment. There wouldn't even be a secondary market if that was true. You see what I'm saying? So, watch this. Serve as payment itself. Now, if not, explain why. And cite your source. Because I don't want to make it seem like I'm trying to tell it what it wants to say. So let me get here. So let me go here. Let's share this. Because I just want to, before we do that though, let's get back to what we're saying.
Here's to the lender the repayment of the loan. Stop right there. So you telling me the actual instrument itself pays for itself? That's exactly what this just told you. Y'all overcomplicated because you weren't taught how these things work. You weren't taught how to actually perform, okay?
So we wasn't taught. We don't know how it goes. We're stupid. We're dumb. We're not thinking outside the box. No, a mortgage agreement or security instrument does not serve as payment itself. It is legally distinct from actual currency, funds, or the promise to pay. I think I just went over that. Instead, its sole function is to act as collateral to secure a separate debt. Yeah, to secure their interest in the property. According to the Consumer Financial Protection Bureau, a security instrument such as a mortgage or deed of trust is a legal document that establishes a lien against your real estate. It gives the lender the legal right to foreclose on and sell your home if you fail to repay on the loan. I think I said that.
You're rocking with the best.
According to the CFPB. So me and the regulatory agencies, I think we're on the same page. And this is why you would never see claims come up out the new culture empire, even making a sentence of similar to what you hear. The security instrument relies on a companion document called the promissory note. The physical distinction between how these documents function include the promissory note is the debt, your actual IOU, or promise to pay back the borrowed cash under specific interest rates and terms. The security instrument, the collateral, simply secures the promissory note. It links the debt to the physical property. That's all it is. Now, case law, confirmed by legal outlines via attorney's title guarantee fund, which notes that a mortgage merely grants a security interest, whereas the promissory note serves as the actual evidence of debt. That's kind of simple.
For things around here, we perform our duties. Stay with me. You got to start learning what these words really mean, okay? So that means the security instrument basically pays for itself, y'all. That's exactly what this means. All renewals and modifications of the loan, it don't matter what they do, flip flop it, whatever they want to do with it, it pays for itself.
You hear that? The security instrument pays for itself. So why don't you just go file a lawsuit and just tell the judge, hey man, we have a problem here. The security instrument pays for itself. Why don't we just tell the judge that? Huh? But I'm trying to figure out. Yeah. So boy. Sometimes I just be trying to figure out, do they really believe this stuff? Or is it more like a shock value? Is this really like the shock? Like, do we do it? Are they doing this to kind of get you in shock? Regimen versus Deutsche National Bank, August term 2013. David Rajaman, Edith Gonzalez, and all of them, I think they are the individuals, the plaintiffs. It's a lot of them. In Deutsche Bank. Appeal from a, I'm sorry, let me give you the date. Docket number 13-1614, June 30th, 2014. So let's do this. Rajaman versus UTSCH National Bank. Yeah. That's all you got to do. And I want you to, what I want you to do is see if there's any similarities to what you hear online versus what you hear. So the plaintiffs are David Rajaman, Ida Gonzalez, Larios, Jesus Valdez, Maurice Nunez, and it's a lot of people. The defendants is Deutsche National Trust Company, a national banking association, individually as trustee of FFMLT Trust 2005-FF8, Trust 2006 FF3, FFML Trust 2006 FF11, and FF13, New York Common Law Trust. Now, how much do you want to bet that although they're the plaintiffs, they're still in default? How much you want to bet that although they're the plaintiff, they're still in default? This is an appeal from judgment of the United States District Court for the Southern District of New York. Lower Taylor Swain judge dismissing for lack of standing and hence failure to state a claim. Plaintiff's mortgagor's complaint alleging that mortgagee's assignment of the loans and mortgages to defendant trusts were ineffective because the assigners failed to perform certain obligations under assignment agreements to which plaintiffs were not parties. And this is where I blame the lawyers back then. 2006, 2007, let's say about 2008. Lawyers were raising these arguments, and the courts were allowing these arguments to go through in the early stages. But you had like 2006, 2007, 2008. And the problem with that is, what the judges were doing, that's kind of exactly how it's supposed to go. But they started to notice that borrowers were getting free house. They were still getting awarded the home, even while they're in default. But let's go beyond the surface. What happened was the secondary market started to get a little frustrated. And remember when I say the secondary market will always win? You will never defeat the secondary market, no matter what your claims are, no matter what your evidence is. You fly too close to the sun, you will get burned. So now what they do is they're going to dismiss the case without prejudice. And as long as they're within the statute of limitations, according to each state, they're going to file again. Or what they'll do is they'll transfer it to a new servicer. Then the servicer will make a demand for payment, and then they'll resue again. Or if that fails, they'll just hijack the title, meaning not per se, meaning they won't remove the security interest. So you'll be stuck. You'll be in the home, but you won't have the security interest removed. So you can't sell it. You can't transfer it. You can't even loan against it. And that's the bank's way of saying, you ain't about to get off scotch-free. Oh, yeah, they will keep that security, that lien until it's fully paid off. Now, affirmed. Now, they argued the transfers were ineffective because the assigners failed to perform certain obligations under the assignment agreements to which plaintiffs were not parties. So if the sponsor, if the lender and their subsidiaries has an agreement with investors What makes you a party to that agreement? Signed agreement. That's just like me and somebody else have an agreement and you come in and say, oh, you did this wrong. You're not a party to their pulling their service agreement. It means nothing if they did something wrong. If they did something wrong, let the investors get to them. That doesn't mean the borrower has any rights. Plaintiffs David Rajaman, who mortgaged their homes in 2005 or 2006, appealed from a judgment of the United States District Court for the Southern District of New York. Oh my gosh, you in New York too? Lower Taylor Swan, dismissing their claims against 4 trusts to which their loans and mortgages were assigned in transactions involving the mortgage bank and against those trustee. Defendant Deutsche National Bank, National Trust Company. Plaintiffs sought on behalf of themselves and others similarly situated monetary. What did I always tell you? They're always going to chase money from the securitization trust. This is back in 2014, 12 years ago. When they think securitization, they're always thinking, I can keep the home and I can get money back. So they sought monetary and equitable relief in a judgment declaring that defendants do not own plaintiffs' loan and mortgages on the ground, inter alia, that the parties to the assignment agreements failed to comply with certain terms of those agreements. No class action was certified. The district court finding that plaintiffs were neither parties to nor third-party beneficiaries of the assignment agreement and hence lacked standing to pursue these claims. Granted defendants' motion to dismiss the complaint for failure to state a claim. Once again, that represents 95% of mortgage arguments online. I know you heard people in their lives make that argument. The PSA, pulling the service agreement. On appeal, plaintiffs contend that they plausibly asserted standing and asserted plausible claims for relief. For the reasons that follow, we conclude that the facts alleged by plaintiffs do not give them standing to pursue the claims they asserted, and we affirm the judgment and dismissal. So this is what I mean. You can know all the stuff about the securitization. You can know it. It doesn't mean jack squat shit what you know if you don't know how to argue it and if you don't understand arguments that the court's just not going to allow, regardless of how right you are. It's just not going to fly. So this is where they get personal. This is what it should be. It should versus dealing with what it is. This is why I think 98% of pro se litigants that are involved in their own cases should not be filing complaints in their own name, typed up by themselves. You want to know why? Because they're too emotionally involved. They're too involved. And they become biased to their own reasonings, their own claims and they need that extra third party who is uninterested, who has no dog in the fight for real. That's going to give you an objective view and look at exactly what you need to prove your claims. The problem is pro se litigants think they prove their claim when they stake the claim or when they know what happened. This is what happened that I know. You knowing what happened is totally different from your arguments of the facts and elements of the case. We accept the factual allegations in plaintiff's third amended complaint, which incorporated certain factual assertions, declarations, and attached exhibits submitted by defendants at earlier stages of this action, as true for purposes of reviewing the district court's dismissal for failure to state a claim on which relief can be granted. Meaning, so when they review it, they're going to look at it like they're telling the truth, like they're 100% correct, until they stop becoming correct. Basically, they're giving you the benefit of the doubt. Plaintiffs are 5 individuals and 2 married companies who had homes in California and who, in 2005 and 2006, borrowed sums ranging $240,000 to $1,008,000, totaling $3,776,000 from a bank called First Franklin, a division of National City Bank of Indiana. Each plaintiff executed a promissory note secured by a deed of trust on the home, equivalent to a mortgage under California law, in favor of First Franklin. The note signed by plaintiffs stated that plaintiffs promised to pay the stated amounts of principal and interest to the order of First Franklin. Right there. Right there. Right there. What is the first thing that the court is going to inspect? Who is entitled to pay? Who is obligated to pay? Who's entitled to receive? And let me give you a news flash. If you don't have a legal answer for that, nothing else in your complaint matters. Everything else is just a formality. See generally UCC-3104 and 109. Now, why did they use generally? Because the definition of a negotiable instrument is it's universal all over. These deed of trust signed by plaintiffs, samples of which were attached to the complaint, provide in part in sections titled Uniform Covenants, just like we went over, that the parties agree that the note or partial interest in the note, together with the security instrument, can be sold one or more times without prior notice to borrower. That is standard. Once again, this is your security instrument where they're telling you they can sell it. So why 3-4 years down the line, it becomes such a surprise to the borrowers? Why? How does it become a surprise to the borrower if they're telling you? All right. If they're telling you they can sell the note. TikTok, you see what I'm saying? See what I'm saying on TikTok? You see what I'm saying? Now, a sale might result in the change in the entity known as the loan servicer that collects periodic payments due under the note in the security instrument. You see that? See? That what part of that is an issue? Securitization is legal. Freedom, what's up? Def, what's up? Def in the building. Yeah, everybody in the building. Down to y'all in the building, right? So what I'm trying to get you to see is if you have an issue with them selling it, number one, it's a lose conversation because they're going to do it regardless. But you do realize that you kind of look foolish trying to argue something that, according to your signature, you already knew what was happening. You already know that they can sell it. There's nothing wrong with them selling it. Like if you owe me $50,000 over the next 5 years and I want to move that off my books and liquidate that, hell, I'll sell it for 42 right now, cash money. Here, collect on them. They owe 50 under this. Give me 42.8 right now is yours. I can do that. Have a right. That's part of the country's all right. We can transfer debt. I don't have to just hold on to it. I can sell it. You're going to get far in this system when you start looking at it from their perspective as well. When you start seeing the field from how they see it, you're going to get further. You'll actually realize that it's not as personal as people try to make it seem, like they personally have a vendetta out against you. Because to be honest with you, not to water down the importance of our existence as human beings and as family. People have family and kids and people who love you. But to them, you're just an account number. They're not saying John T is in default. They're saying this account's in default. Who's responsible for this account? John T. Okay, send John T a notice. I mean, it's literally that. And the people who are sending the notice or collecting, they get paid regardless, whether you pay or whether you not. So they don't have no personal interest in it. They actually could care less if you pay or not. They're just there to do their job. Deutsch is the trustee of the 4 defendant trusts, which were created under the laws of New York. Ladies and gentlemen, you need to understand what the laws of New York say and what it means. They ain't letting you get off like that. If you look at how these trusts are governed under New York laws, why do you think these securitization trusts are all governed under New York laws? Because it's favorable to investors. Well, just look at the situation. What's in New York? The money capital of the world's in New York. You think they're going to make laws that's going to benefit us more than the secondary market? I keep telling you, these consumer laws, they have no ranking over the secondary market, over the shadow banking system. Absolutely not. 1 second, let me grab something to drink.
They studying the source now. Supreme Elite. New Empire Talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is a blueprint. Supreme Elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag play.
All right, let's get back to it.
You're rocking with the best.
All right, TikTok. So generally, defendant trusts whose names begin with First Franklin Mortgage Trust or the initials FFMLT maintain that they were created in connection with securitization transactions involving mortgage loans originated by First Franklin between January 1st, 2004 and January 1st, 2007. You hear me? Residential mortgage loans, rather than being retained by the original mortgagee, may be pulled and sold into trusts created to receive the stream of interest and principal payments from the mortgage borrowers. The right to receive trust income, aka the right to receive payment, is parceled into certificates and sold to investors called certificate holders. The trustee hires a mortgage servicer to administrate the mortgages by enforcing the mortgage terms and administering the payments. I swear to God, if we created securitization trusts, I swear to God, you ain't letting nobody slide on that getting paid. Don't you see how much money we making and how much at risk we at if they don't pay? Y'all, you wouldn't let nobody slide. I ain't letting nobody slide. And I say that because you have to look at this, even in your home's involved. You got to look at this business. You can't take nothing of this personal. You see what happens when they take personals, these personal, emotional ass filings. Please, oh, it's God, and they don't give a damn about that. Now, the terms of the securitization trust, as well as the rights, duties, and obligations of the trustee, seller, and servicer are set forth in a pooling and service agreement. The complaint alleged that defendants claim to have purchased plaintiffs' loans and mortgages through intermediaries from First Franklin and to have the right to collect and receive payments on plaintiffs' loans pursuant to written agreements. Each securitization transaction involved written agreements with the assignment agreements, one of which is called a pooling and service agreement. The PSAs, by which their terms are to be governed by New York law, provided inter alia for the formation of the relevant trust, the conveyance of a pool of mortgages to Deutsche Bank as trustee, the issuance of mortgage-backed securities representing interest in the pooled loans, and the servicing of the pooled loans by the servicer. So when they say securitization is illegal, no, the court is explaining how it goes. The courts never said this is illegal. No, take out the word illegal, and I just need something to fight. I need a boogeyman. Don't want to look in the mirror because that's the real boogeyman, but I need a boogeyman. I need an external boogeyman. Because to be honest with you, 99.99% of people's problems starts with the non-payment of the debt that they agreed to pay. That's 99% of the problems. It starts right there. It doesn't start with a breach of contract. It doesn't start with unconscionable contract or they didn't disclose. No, it started with your non-payment because when you were current, you didn't give a good goddamn about securitization. So does that act like it's a big problem now? Defendants claim that in each such transaction, First Franklin sold a pool of mortgages to a sponsor, which at closing sold the loans through its affiliate, a depositor, to a trust. Thus, the intention of the parties to the sales and securitization transaction was that Deutsche Bank will become a trustee. As trustee, the legal owner and holder of the notes and deeds of trust originated by First Franklin. I'm gonna save it for the class. Woo wait. Plaintiff's challenge to the assignment. That's where you first mess up at. If I read a mortgage complaint filed by somebody, and the very first thing that they start talking about is the assignment, I'm not even going to finish reading the complaint. Because you've already lost right there. The complaint challenged defendants' ownership of plaintiffs' loans and mortgages, right to collect and receive payment on the loans, and right to commence or authorize the commencements of foreclosure proceedings where payments have not been made or received. See the third complaint, amended complaint. On the ground that inter alia, that there was a lack of compliance with provisions of the assignment agreements. The lack of compliance of their own agreements does not affect your obligation to pay under the note. And that's the translation. Where's the connection? Where does your monthly mortgage payments, your only job is to pay the servicer. How does their pulling the service agreements on the back, how does that affect your obligation to pay? Don't worry about the servicer's right there. That's where you send your money to them. You don't worry about it. It's going to get to the party who's entitled to it. You just send it to the servicer. What's wrong with that? Now, you get what I'm saying? It's not affecting your right to pay. Did it by the assignment? Did it cause your bank to put a freeze on your account because your mortgage was sold? Did it cause the bank to freeze the account? Did they do a fraud alert on your account? Did your bank say, hey, it appears that we've seen that your mortgage was sold to XYZ bank, but the servicer here, there's something wrong here. We're not going to. No. Doesn't matter. Your sole purpose is right there to the servicer. So how did their agreements affect your relationship from the payments going to you to the servicer? The complaint alleged that the assignments were defective because plaintiff's mortgage loans were not specifically listed in the mortgage loan schedules or other attachments to the assignment agreements. You do realize that those attachments are not filed anymore. They don't file them with the statements. The SEC, they don't file them. See, you're thinking about that early 2000s, 2001, 2002, when they used to have Schedule A in the list of the properties. You do realize they don't do that anymore. Indeed, according to the complaint, the assignment agreements did not specifically list any promissory note, mortgage, or deed of trust that was allegedly sold, transferred, assigned, or conveyed to defendants. The complaint also alleged that assignments by First Franklin to Deutsche Bank of 4 of a plaintiff's deed of trust were executed and publicly recorded in 2009 and 2010. After First Bank had ceased operations in years after the securitization transactions took place. Plaintiffs argue that the execution and recordation of these mortgage assignments after the securitization transaction that created the defendant trust indicate that these mortgages were not included in the mortgage loan pools that were sold to the trust. In addition, the complaint alleged that two PSA's provisions as to documents that were to accompany the conveyance of loans and mortgages to the trust were not complied with at the time of the securitization transactions. Ooh. There were A, provisions stated that an affiliate of the sponsor has delivered or caused to be delivered to a named custodian the original mortgage note bearing all intervening endorsements necessary to show a complete chain of endorsements from the original payee. And B, a similar provision as to delivery of the originals of all intervening assignments of mortgage with evidence of recording thereon, evidencing a complete chain of ownership from the originator of the mortgage loan to the last assignee. Yeah, but ask yourself, that is a defect that HUD can make them cure. That is a defect that they can cure on their own. But once again, that is not a defect to cause you to stop paying. It doesn't cause that type of a defect. 2, the alleged injuries to plaintiffs. The complaint implied that plaintiffs made their loan payments to Deutsche Bank and Defendants Trust. I don't know who to pay. I know, I see where it's going. It alleged that defendants claimed and asserted that payments were due to them monthly, and that defendants received and collected money from payments made by lead plaintiffs and class members based upon defendants' claim of rights, titles, and interests in the loans in issue in this action. The proposed class is all persons who took loans originated by First Franklin in 2004, 5, and 6, for which Deutsche Bank claims to act as trustee and for which defendant trusts have received or collected payments since January 1st, 2004. The complaint also alleged that defendants have commenced or authorized the commencement of foreclosure proceedings where payments have not been made or received, and that individuals and families have lost their homes and real property in foreclosure proceedings based upon the loans, including promissory notes and deed of trust, in issue in this action. The complaint alleged that insult and declaratory judgment as a result of the alleged failures with regards to the assignment agreement. Deutsche Bank and Defendant Trust have not obtained ownership over and do not own plaintiff's promissory notes and deed of trust, and have no right to collect and receive payment on the mortgage loans, and have no right to foreclose on plaintiff's real property in the event that payments are not made. So basically, you're saying they lack standing. That's what I'm pretty much getting from it. While alleging that defendants received and collected money from plaintiffs that defendants were not entitled to receive and collect, and seeking as restitution and as damages all payments on the mortgage loans in issue, money collected and received by Deutsche and Defendant Trust and their servicers, agents, employees, and representatives. Wherefore, the complaint did not allege or imply that any plaintiff or putative class members made loan payments in excess of amounts due, made loan payments to any entity other than defendants, or was subject to duplicate billings or duplicate foreclosure actions. Right there, the judge is saying something. That's your argument. That's your argument. See how the judge slid that in there? However, basically, they didn't say, oh, the judge did a brilliant job sliding that in there. That's your claim right there. In this case, that's their claim. You notice that they never alleged that? And that's really their legal claim. You notice that's their legal claim, but they didn't raise that at any time. Look, say it again. Look. The complaint did not allege or imply that any plaintiff or putative class member made loan payments in excess of amounts due. Bam. See, they right there. Let's pause right there. In excess of amounts due. Right there will be a hellified claim. But you got to ask yourself a question. By looking at my contract, looking at my payment history, how the hell can I recalculate all the payments I made and prove that all these payments I made on a mortgage were in excess of what they're legally entitled to collect? See, this is when you get past the surface level social media online gurus talking to securitization and how they structure, to really get into the X's and O's and how they do things behind the scenes. See, it's going to take that to pull that off. You can't pull that off with general information. You got to get deep into their operations. The dismissal of the complaint. Defendants moved to dismiss the third amended complaint on the ground, inter alia, that plaintiffs lack standing to pursue claims based on alleged violations of agreements to which plaintiffs are not parties. There you have it. In an opinion filed March 28, 2013, the district court granted the motion to dismiss the complaint for failure to state a claim on which relief can be granted, finding that plaintiffs lack standing to challenge defendants' ownership of the notes and mortgages based on the alleged non-compliance with the terms of the PSAs. Ask yourself this question. Do you still hear that as a mortgage defense today online? When they fire up the stream saying they did this and they did that and they can't do this and the law says they can't do it and it's illegal and it's unlawful and it's unconscionable. There wasn't due process. There wasn't this. They did this. They did this. They did this. Just pull the legal lens down and just throw it up under what they say. Just put it right under the legal lens. That's all you got to do. Argument stops dead in their tracks. The court pointed out that plaintiffs do not claim to have been parties to the PSAs, and none of the PSAs includes provisions indicative of party status for borrowers or mortgagors. The weight of case law throughout the country holds that a non-party to a PSA lacks standing to assert non-compliance with the PSA as a claim or defense unless the non-party is an intended, not merely incidental, third-party beneficiary of the PSA. You notice how you go back to Phyllis Horace versus LaSalle Bank? You notice how no one in Alabama has won off by citing that case law. And you notice how the courts around the world disown that judge. I think the judge ended up dying afterwards. You notice how they all rejected that reasoning. And you notice how they was very serious and very technical when they said, unless the non-party is an intended, not merely technical, third-party beneficiary of the PSA. You know what that means? Well, in substance we are. Well, in economically we are. No, you have to be registered, certified. You get your monthly reports. You get your K1s and you get your 1099 sent to you. You get your shareholder statements. You get your certificate holder statements. You're filing the interest income from these certificates on your tax returns. That third-party beneficiary. If you know you haven't done any of those, you are not a third-party beneficiary. And I'm telling you this, and this is to save you. You're not going to win that argument in any court in the United States of America. Pick it, state, federal, chancery. You're not going to win this argument in any court in the United States of America. This is a universal rule. The court stated that the intent to render a non-party a third-party beneficiary must be clear from the face of the PSA, and that plaintiffs have not alleged any facts that would support plausibly a claim that they are intended third-party beneficiaries of the PSAs. Thus, plaintiffs lack standing to challenge defendants' alleged ownership of the notes and deeds of trust or authority to foreclose based on non-compliance with the PSAs. And ladies and gentlemen, they're still online peddling these same arguments. They're still accepting payment for mortgage defense with these arguments in mind. This is why they want you to get an audit so bad. There is nothing in these private investigators' securitization audits that we can't already find out on our own. And in addition, the court noted the complaint allegations that mortgage loan schedules accompanying the assignment agreements did not reflect plaintiff's loans. The court rejected that allegation as baseless, finding that the mortgage loan schedules in question submitted by defendants in support of their motion to dismiss the third amended complaint do in fact identify the relevant loans. You want to know why they had it there? Because they don't file them with the SEC anymore. They don't file the schedules on Edgar because privacy laws has impacted that. You're not going to go on Edgar. That's that early 2001, 2002 Gene Keating stuff. Told you I can pinpoint the year. Told you I can pinpoint the year when it first became a phenomenon. On appeal, discussion. On appeal, plaintiffs contend that the district court erred in dismissing the complaint, arguing inter alia, pretty much among other things, that they have a concrete interest in putting to the test defendants' claims to own plaintiff's mortgage and mortgage documents. Although it is not clear whether the status of plaintiff's mortgages was in the record before the district court in 2013 when it dismissed the complaint, it is now undisputed that, and this is what they are going to do. The courts, the judges, when you bring these claims and you're coming in as the plaintiff, when you step into court as the plaintiff, I'm telling you, you better make sure you are current. There's no other way to be the plaintiff. I'm telling you, because every court is going to do this right here. It is now undisputed that in 2009 or 2010, each plaintiff was declared to be in default on his mortgage and foreclosure proceedings was initiated. What did I say? The courts are always going to go back to your default.
You're rocking with the best.
They're all you. It doesn't matter that you came in as the plaintiff. If your account is in default, the courts are not moving past that. Do you know how many stages of proceedings it's going to take in order for the court to start moving beyond that and start to entertain your substance? Y'all, it took us 2 proceedings just to get the judge to finally say, you know what? I'm starting to agree with the defendants now. We've been saying the same thing for the past 2 proceedings in motions that's filed. Loan Depot will not engage in a response to our motions. When she had them sovereign citizen teachers, they was responding left and right. Motions to strike. They have remained mute since March 6th. I can't get them to engage. I just want them to respond to one, but they won't fall for the trap. They won't fall into the trap. I keep moving that trap closer, keep covering the trap, disguising the trap, and they won't fall for the trap. They will, as of yet, they will not fall for the trap, because if they respond, that's their ass. They're going to hide behind that judicial default. See, they don't got to respond now. They're going to hide behind the judicial default, in which that was their court situation before she came to me. I said, man, if you was not in, because now we got to fight just to get you out of judicial default. But just because you're in a judicial default, and I don't even know why these gurus didn't even have her to do a simple response. Even though you're in a judicial default, there still has to be an evidentiary hearing. So they still got to prove the amounts due. And that's what we keep sticking them at. And we keep hammering the amounts due, keep filing motions around it to get them to respond. Because I just need them to respond one time, and I got them. But since they don't want to respond, now we threw it back in front of the judge, put it as part of the record, and just say, hey, judge, now look at this. What are you going to do about it? To the point where they continued the July 10th hearing to September 1st on the court's own motion. The court's own motion. They continued it. How? I don't act. They continued it on the court's own motion. So now we got the transcript, we got the record. So now we're taking everything they said throughout the last 3 hearings, everything they said. And you notice how I do with these gurus? They said this, but now let's get to what really goes on. So now I'm just chipping away at the iceberg. We getting deeper. We getting into uncomfortability. We getting to uncomfortable waters. I'm starting to drag Loan Depot out into the deep waters. I'm starting to drag them out in deep waters, exactly where I want them. I'm about to drag them out in deep waters. As soon as I get them right there at the right depth, I'm going to execute the death roll. And I'm going to drown their ass right in the middle of the water and leave them right there. Leave the rest of the carcass right there. Court is more about rules of procedure than anything else. And drafting a complaint is all about the strategic drafting, the timing, the flow, how to connect the arguments back to substantive case law, how to bring arguments in line with the court rules of procedure, how to provide authoritative guidance, and how to provide authoritative academia, well-respected professionals to support your position. So basically what I'm saying, Your Honor, I'm not just saying this. You got a top respected professional whose findings has been accepted by other courts throughout the United States saying the same thing. Don't you think I deserve a little credibility here? Hey, I'm not only saying this, your other sister circuits are saying this. Hell, I'm not only citing it, this is your court doctrines. See, they like to use maxims. I like to use court doctrines, meaning it's the unspoken rule. Meaning, this is how we're going to rule in situations like these. Hey, not only, Your Honor, you know I like to prove the multiple venue thing. So, Your Honor, if this was bankruptcy, she would be entitled to more than the disallowance of their claim. If I was the IRS, oh, they definitely will be reclassifying these so-called items of income. Your Honor, if we was in a federal court right now, federal courts of judges and rulings are all on our side. And Your Honor, I'm not even saying that she doesn't owe. I'm not saying that she's not obligated to pay. I'm not saying that. But Your Honor, let's look at how they're calculating her obligations and her debt. And just look at how they calculate these on their financial statements of position. Your Honor, they say she owes this, but in reality, she doesn't owe that. Your Honor, they made this amount of payments on their mortgage, but Your Honor, you see this big chunk right here? None of this went to the true use and forbearance of money. Do you think it would be equitable to take all the funds that they applied to their own securitization vehicles and apply it to the principal, Your Honor? Don't you think that would be an equitable thing to do? See, we're not asking for a free house. The quickest way to lose a home is to ask for it back. You never ask for the home back. You never ask for a quiet title when you're in default. You're never going to win that. You're never going to get a house for free when you're in default. When I mean for free, legally recognized, legal ownership, no liens, no clouded title, no clouds around the title, no title washing scam, no nothing. You only bring up quiet title when you are current, you've been timely for extended period of time, and you're not in default. And that's the only way a quiet title will be entertained. And then in a quiet title, that doesn't mean your debt goes away. You have to prove to them how you've already satisfied the balance or you are close to the end. Now you got to take the whole accounting structure, the numbers that's on your contract, you got to reconstruct the whole contract. You have to reconstruct the whole contract. Item by item. The interest calculations, your monthly payment calculations, how much really went here, what went here, what went here, the misclassifications of the item. You gotta lay the whole 9 out for them. And no, this is not something that's in theory. This is reality. Now, in 2009 to 10, each plaintiff declared to be in default of his mortgage and foreclosure proceedings were initiated. That, in connection with the institution of said foreclosure proceedings, Deutsche Bank, as trustee of one of the defendant trusts, claimed to own each plaintiff's mortgage, and that plaintiffs are not seeking to enjoin foreclosure proceedings. Assuming that these concessions have not rendered plaintiffs' claims moot, we affirm the district court's ruling that plaintiffs lack standing to pursue their challenges to defendants' ownership of the loans and entitlement to payment. Don't even have standing to raise it. So on social media, online, you can do it. Look at this. This is what they're doing. You can do it. Bobby Boucher, the water boy. You can do it. But when you put it under the legal lens, you don't even have standing to utter it. That's the difference between social media, online gurus, and court reality. What's being spoken online is totally different to how it's presented in court. You got to stop using what you think happened, what you heard online, and thinking court operates the same way. Court operates in its own way. You're either going to get in line with court or you're going to fall yourself on the ass end of the stick of their rulings every time. And to be 100% honest with you, when you bring claims as technical as the New Culture Empire does, it rarely is ever going to get to a judgment. Or it's going to be a settlement before it gets to a final judgment, because you're going to be setting new precedents. They're going to settle before it gets to judgment. Told you, I drag them out deep waters and ask them to settle before I drown them. You don't want to settle? Okay. Don't matter to me. The question of standing is whether the litigant is entitled to have the court decide the merits of the dispute of particular issues. Right there. See, this is the flip side of being a plaintiff. You got to bring your merits. You got to satisfy your elements, and you got to prove your case. You got to prosecute your own case. So this is why when you see in these spaces, everybody wants to be the defendant, because it's easier to defend than bring your own claims and make them respond to your elements, because in social media, they have nothing for you when you're the plaintiff and current. They really don't have shit for you. They really don't know what to do. In their minds, when you're plaintiff and current, you have no claim. There's no use for you being in this space, as was told to me before. What claim would you have if you're plaintiff and a current? I said right there, the mere fact that you asked that question, brother, is the difference between how me and you operate. Everybody thinks that just because you're on the panel together, just because you have a mic and an opinion, that everybody's on the same level, or everybody's powwow and just trying to figure the system out, or we're trying to get, I know the fuck we're not. 9 times out of 10, when I come on the panel, I'm pretty much there to challenge what you believe is true. Keyword, what you believe is true. See Worth versus Selden. The plaintiff bears the burden of establishing such standing. We review de novo a decision as the plaintiff standing to sue based on the allegations of the complaint and the undisputed facts evidence in the record. If the court also resolved disputed facts in ruling on standing, we will accept the court's finding unless they are clearly erroneous. For that reasons that follow, we conclude that plaintiff established neither constitutional nor prudential standing to pursue the claims they asserted. Constitutional standing. The irreducible constitutional minimum of standing under Article 3 of the Constitution includes that requirements that the plaintiff must have suffered an injury in fact, which is a concrete and particularized, an actual, imminent, non-conjectural, or hypothetical. The exact opposite of what they talk about online. And let me ask yourselves a question. Why does every time you're in state court, you always ask the judge, is this an Article 3 court? Article 3 is a federal concept. State courts are more like under Article 7. So no, a state court wouldn't be an Article 3 court because Article 3 only deals with federal courts. Article 7 is more of a state court. Now, let's get here for a second. Article 3 courts, Article 3 courts versus Article 7 courts. What's the difference? Article 3 versus Article 7. Now, Article 3 meant to me Seventh Amendment. I'm sorry. So the Article 3 courts, constitutional courts, they represent the former judicial branch of the government. So you got the Supreme Court, Court of Federal Appeals, Federal District Courts, U.S. Court of International Trade. Judicial protections. We ain't got to worry about that. Jurisdiction, cases regarding the Constitution, federal laws, treaties, and maritime law. Article 1, legislative. These are tribunals created by Congress using its legislative powers under Article 1 rather than by judiciary authority of Article 3. The courts include the U.S. tax courts, U.S. Court of Federal Claims, military court. The 7th Amendment. That's what I said Article 7. 7th Amendment provides the right to a trial by jury in civil federal lawsuits where the financial stakes are high. The conflict. Recent landmark legal battles focus on whether Congress can use executive agencies, Article 1 style tribunals, to fine citizens without giving them a jury trial. Now, does an Article 3 court override a state? Does an Article 3, meant to make 7th Amendment, y'all. Article 3 court override a state court in a foreclosure? Even though this case is a federal court they brought. Generally, no. An Article 3 federal court cannot override, undo, or reverse a state court's foreclosure ruling. Under the U.S. legal system, federal courts and state courts operate on parallel tracks. Federal district courts are not superior to state courts and do not act as appeal courts for state level lawsuits. And this is on the Case Mind 24 sites. And this is Case Mind, the Roker-Feldman doctrine, right? So basically, the Roker-Feldman doctrine is if this, you can't use a federal lawsuit to try to undo a state judge's ruling. The Rooker-Feldman doctrine. Okay. So yeah, you can't do that. Can I get back to the case? Let's get back to the case. I think the case is here. Here we go. All right. Plaintiffs allege that their loan and mortgage transaction was First Franklin took place in 2005 or 6. That defendants' claims asserted that payments were due to them monthly, and that for loans taken out by plaintiffs and members of the class they seek to represent, defendant trusts have received or collected payments since January 1st, 2004. Plaintiffs asserted that they were suffering damages with each and every payment to defendants on the theory that defendants were not proper parties to receive and collect payments. But plaintiffs acknowledged that they took out loans in 2005 or 2006 and were obligated to repay them with interest. And they have not pleaded or otherwise suggested that they ever paid defendants more than the amounts due, or that they ever received a bill or demand from any entity other than defendants. Thus, there is no allegation that plaintiffs have paid more than they owe or have been asked to do so. Right there. Social media, that's the code right there. You want to break through on your mortgage? Right there. Right there. And that's the problem. Being able to get around the legal binding debt is the biggest code that they cannot crack. This is why you have discharge processes. This is why you have send this document in. Because in reality, they don't know how to step in front of a court, a competent jurisdiction, and tell the judge, I know the contract says this, but Your Honor, I don't owe what's on that contract. It's out of their league. That aspect of the game right there.
You're rocking with the best.
That is the pot of gold at the end of the rainbow. That is the pot of gold at the end of the rainbow. Now, the suggestion that plaintiffs were in imminent danger or indeed any danger of having to make duplicate loan plaintiffs is thus entirely hypothetical. For the same reason, the complaint asserts that defendants have commenced or authorized the commencement of foreclosure proceedings where payments have not been made or received does not indicate that an actual imminent rather than a conjectural or hypothetical injury. Plaintiffs have acknowledged on this appeal that they were declared in default on their mortgages and that foreclosure proceedings were instituted by Deutsche Bank, claiming to own the mortgages in 2009 or 10. Just as there were no allegations in the complaint that any entity other than defendants had demanded payments, there was no allegation of any threat or institution of foreclosure proceedings against any plaintiff by any entity other than defendants. And had there been any entity that asserted a claim conflicting with the right of Deutsche Banks to foreclose on a plaintiff's mortgage, surely the interposition of such a claim would have been alleged in the third amended complaint, which was not filed until 2011. On appeal, plaintiffs preferred to assert injury by arguing that the alleged defects in the assignments of the mortgages will prevent Deutsche from being able to reconvey clear title to plaintiffs when they pay off their mortgage loans. How you know damn well you ain't paying your mortgage? We note that such an injury was not alleged in the complaint, and it's difficult to view it as other than conjectural or hypothetical, given that plaintiffs several years ago defaulted on their loans. That's why I made the statement I just made. We conclude that plaintiffs failed to allege injury sufficient to show constitutional standing to pursue their claims. Even if plaintiffs had Article 3 standing, we conclude that they lack prudential standing. The prudential standing rule normally bars litigants from asserting the rights or legal interests of others in order to obtain relief from injury to themselves. Meaning you can't copycat. No copycat filings. You got to get it out the mud. You got to do that research out the mud. You can't copy.
You're rocking with the best.
We know it's great. We know it's immaculate. You can't copy.
You're rocking with the best.
You got to get it out the mud. You got to put that work in. You got to put that work in. You got to put them hours in. You got to put that sacrifice in. You got to have that discipline. You got to have that drive. You got to have that motivation. You got to have that will. You got to be willing to go lengths that the average person is not going to go. That boring shit, that confusion shit, the shit you got to read about 5-6 times before you start to understand. For most people, some people read it once, you got it. It's that looking beyond what's on the paper, seeing around the corner, seeing over the hills, through the mountains, anticipating. Right. The plaintiff generally must assert his own legal rights and interests and cannot rest his claim to relief on the legal rights and interests of third parties. Plaintiff have advanced several theories for prudential standing. Each fails. Breach of contract theory. It's like they raise the same arguments. How can we have so many different people with so many different minds, so many different ways of thinking, so many research abilities, but they all seem to all say the same thing? The principles that any contractual provision may be waived by implication or express intention of the parties for those whose benefits the provisions inures, and that strangers may not assert the rights of those who do not wish to assert them. Underline the rule adhered to in the New York whose law governs the assignment agreements, that the terms of a contract may be enforced only by contracting parties or intended third-party beneficiaries to the contract. See Mendel versus Henry Phipps Plaza West Inc., 2006. Mere incidental beneficiaries of a contract are not allowed to maintain a suit for breach of the contract. That is your Phyllis Horace versus LaSalle National Bank, Alabama case. This rule has been applied to preclude claims where mortgagors have sought relief from their own loan obligations on grounds such as those asserted here. See Simmerig versus Merrill Lynch Mortgage Investors, Inc. Plaintiffs lack standing to allege a claim for breach of the PSA because they are not parties to the contract, nor do they allege that they are third-party beneficiaries to the agreement. Indeed, in an action brought by successor trustees of another First Franklin Mortgage Loan Trust, the appellate division of the New York Supreme Court ruled that mortgagors lack standing to assert such breaches, citing as authority the opinion of the district court in this very case. While holding that the plaintiff bank was not entitled to summary judgment in its action to foreclose the defendant's mortgage, the appellate division affirmed the lower court's denial of the defendant mortgagor's motion to dismiss the foreclosure complaint, ruling that defendants did not have standing to assert noncompliance with the subject lender's pooling and service agreement. So another case in denying another borrower cited this same case here. That's what the judge is saying. The New York Supreme Court cited this case. Oh yeah, and that was a state case that the federal court is citing. So you Article 3 federal law overrides the state. No, the fuck it doesn't. Not necessarily in the courts. Not necessarily. Bank of New York Mellon versus Gales. Here, plaintiffs contend that their loans were not acquired by the defendant trust pursuant to the assignment agreements of which the PSAs were a part, because plaintiffs allege parties to those agreements did not perform all of their obligations under the PSAs. Although non-compliance with a PSA provision might have made the assignments unenforceable at the instant of the parties to those agreements, the district court correctly noted that plaintiffs were not party to the assignment agreements, and plaintiffs have not showed that the entities that were parties to those agreements intended that plaintiffs whose financial obligations were being bought and sold would in any way be beneficiaries of those assignments. We conclude that the district court properly ruled that plaintiffs lack standing to enforce agreements which they were not parties and of which they were not intended beneficiaries. And you guys can read on that case. It's a good way to stop it right there. It's just another reason, another way to show that 98% of mortgage loan defenses online are flawed. And actually, the scary part is that you're walking yourself right off the fiscal cliff, but you don't even realize how close to the edge you are. Mortgages and defenses in the courts, universal throughout the United States, they're only looking for a few things. And unless you are the plaintiff and you're current and you can bring all your claims, assuming they are recognized, when you are the defendant, you must respond to the allegations made. You can't bring up or raise things that the plaintiff didn't assert in their complaint. So keep that in mind. The mortgage, the corporate side of the mortgage financing with C.L. Ricks, Fannie Mae Senior Analyst, will be going down July 14th, 2026. Reserve your seat now or be sitting on the sideline, still trying to figure it out with your online social media gurus. Come hear from a professional on what goes on after you close. I like to say that, after you close. What better way to hear it for the professional who does this for a living? One gone, and I'm going to catch you on the...
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers. They were reading memes. He was reading filings. Planning out the dream. Turn every late fee into case. Pablo crazy for this motherfucker. Hey, yeah, run it up, bands. Got the bitches jumping out the pan. We slip the bitches all in saran. The cut up in the shit about a backboard. Before I let a nigga hit me with a back door. No fronts, but we ship them out the back door. Got a blunt, but I fill it up with pack dough. Don't call my name while I'm whipping it, yeah, I be whipping it straight. Get me a plate, 1,000 grams, no cut it, sent by the late 20X for the plate. A brick in the safe, the semis, the fully, a switch on the Drake. Blue diamonds, the rest don't switch out the face. Off the ace out of spades, sit by that case, you ain't sliding for nothing, your stick I'ma take. My bitch, she get it, she got it, she paid. Money talks, my bitch, she got it the same. The choppers still sound like a headaway bass. They painted, they seeing great, they on their place. The face when they die, try to make them a case, and these bitches still biting, they taking the bait. She gag on this dick like a sock in her mouth, and these haters, it's 49 sparks on these face. Back on this land, I'm not giving this shit. Go straight to hell, send her my wish. I ain't gon' fuck her, she burner, she white to my girlfriend, that see she just get in the midst like a broke on that car team, sitting on bricks, and they stop for attention, they slitting their wrists. She won't let me fuck, just might slip with some chips, I might step in, I'm out here slip with my dick. Sweat that guy, I want no problems, but solve it. Ballin', selling this way that we chop it. Stop it, you don't have no stocks in your pocket. Drop it, that gun that you know you won't pop it. Pull up in the roads, you know you gon' watch it. The rollie $6, you know you gon' clock it. I get my bitch wet, make her drip like a faucet. They won't call like that, all my bitches are flawless. Hey, yeah, run it up, bands. Got the bitches jumping out the pan. We sit the bitches all in saran. The cut up in the shit about a backboard. Before I let a nigga hit me with a back door. No fronts, but we ship them out the back door. Got a blunt, but I fill it up with pack dough. Don't call my name while I'm whipping it, yeah, I be whipping it straight. Get me a plate, 1,000 grams, no cut it, sent by the late 20X for the plate. A brick in the safe, the semis, the fully, a switch on the Drake. Blue diamonds, the rest don't switch out the face. Off the ace out of spades, sit by that case, you ain't sliding for nothing, your stick I'ma take. Ain't no cigarette, rich as a bitch, but all my niggas to get richer than this. In love with the yayo, I'm flicking my wrist. Back door with nigga, this switch off the pit. 40 your hand, once assist off the hip. 40 more Benzes to flip off the brick. 20 more racks, that's the flip off the flipping. And flipping, this brain's gonna flip out this shit. No roof when I blow out the endo. I got plenty doors, I just pin for my kennel. 200, I matched, no mistake for a rental. High off the molly, I eat out the middle. High off the molly, she suck to a split up. High in my sleep, she gon' suck with the dick up. High in her sleep, I start off with his sister. High as can be, put his dick all up in her. I'm the general, these my gorillas are ace. Stop the shit out you, then you step by the lake. Be spoke with the Stradley, you step by the cake. Play with her, no, she won't step by the 8. Tell that bad bitch to come sit on my face. I got these racks and a hard dick on her plate. Are you rats eating cheese? I hope it is lace. Claim that you ballin', I hope you can play. Hey, yeah, run it up, bands. Got the bitches jumping out the pan. We sit the bitches all in saran. The cut up in the shit about a backboard. Before I let a nigga hit me with a back door. No fronts, but we ship them out the back door. Got a blunt, but I fill it up with pack dough. Don't call my name while I'm whipping it, yeah, I be whipping it straight. Get me a plate, 1,000 grams, no cut it, sent by the late 20X for the plate. A brick in the safe, the semis, the fully, a switch on the Drake. Blue diamonds, the rest don't switch out the face. Off the ace out of spades, sit by that case, you ain't sliding for nothing, your stick I'ma take.